Yes.
And I'm glad, my lord, that the court has finally fixed it for hearing and constituted a constitutional bench, given the importance of the case. Lord, I have been in the PIL space for many years, but I have never seen this kind of public interest involved in any PIL that I have ever done. I mean, the amount of interest that this has aroused is absolutely astounding. Lord, there are, I'll just show your lordship what the electoral bond scheme is. By this petition, my lord, we have this, I am appearing for ADR, and we have filed written submissions which are in volume 1 and start at page 1. We have, in our written submissions, my lord, mentioned that we are challenging in our petition also, we are challenging the amendments brought in FCRA by the Finance Act of 2016. So first, my lord, in 2016, and the issue about whether they could have been brought through the Finance Act or not, I am not pressing right now, though we have taken that issue in our petition. But I am not pressing it for the reason that I want this case to be decided before the elections. I don't want, because I know that your lordship has issued the finance bill issue to a 7-judge bench, and I don't want this to await that. So I'm restricting myself to the other grounds of challenge. So first, my lord, we have challenged the amendments brought to the Foreign Contribution Regulation Act of 26 by the Finance Act of 2016. And in essence, my lord, those amendments were that prior to that amendment, we have actually in our written submissions, my lord, we have given a chart of the amendments. And the amendment regarding the FCRA is at page 10.
I'm sorry, generally, my lord, we don't interrupt. But by a judicial order, my lords have been pleased to separate and detag the issue regarding FCRA. There is a judicial order passed by your lordships.
No, my lord,
Lord, he has started with that, my lord. Therefore, it's.
I'm just pointing out what we have challenged in this petition. If your lordship just sees, in this petition, which is before your lordship today, we have challenged the amendments made to the FCRA also. So by this by way of the finance bill of 2016, you have allowed, and the amendment was, Lord, suppose that prior to that, the foreign company wanted to donate money. The foreign contributions were prohibited. It was earlier political parties and candidates and public servants. One of these cases went to the. By this amendment was. They have effectively permitted foreign contributions by saying judgment of the that any contribution made by way of donation both the BJP and the Congress party through a subsidiary of a foreign company, which is registered in India, at that time will not be treated as a foreign source, which was a subsidiary. So by this amendment, which was a effectively company, you have allowed, and they said so that, for example, my lord, suppose I'm just giving an example. Parties to overcome a foreign company wanted to donate money to a political party through the Finance Act into FCRA. It was earlier totally prohibited from doing so, and in fact, one of these cases went to the. In fact, this amendment was in a way brought in order to overcome a judgment of the Delhi High Court treated to be by which the Delhi High Court held that both the BJP and the Congress party had received foreign contributions through a subsidiary of a foreign company. At that time, it was Sterlite, which was a subsidiary of Vedant Resources, which was a UK-based company.
That was perhaps why the solicitor.
And they said that therefore appropriate action should be taken against these political parties. To overcome that, the Lord, a retrospective amendment was brought through the Finance Act into FCRA by saying that if the donation is made by a subsidiary of a foreign company, in that case also that was a subsidiary, Sterlite was a subsidiary of Vedant